Greetings. This is Attorney Della Welch talking more about the code section. We were at item G. I wasn't able to finish that. However, I wanted to go back and say something about item E, where it talks about the obligations and assets. And I wanted to let you know that when you're at trial, you need to go through each asset individually. I have a case now where there's a used car, and used cars are more valuable. Usually the blue book is used to determine the value of the asset of a used car. And be sure and get that information in, because many times these used vehicles are worth more than when they were purchased new. Now I'll go back to item G. It says the ability of the supported party to engage in gainful employment without unduly interfering with the interests of the dependent children in the custody of the party. Children, as we know, have many needs and are demanding, and if the mother needs to attend to the custody needs of the children, that needs to be factored in. Item H, the age and health of the parties. Many times I've seen where both parties are on Social Security, and sometimes they just leave them there. It depends on the judge in terms of whether the Social Security is shared. I had one case where I did a divorce of a couple who had been married 53 years, and they both came in wheelchairs, and the judge happened to say, I see both of these parties are headed for the rest home. They were both very ill. I asked my client why she wanted a divorce after 53 years of marriage, and she said, oh, I couldn't stand it anymore. So sometimes we have a little humor. Item I, all documented evidence of any history of domestic violence as defined in section 6211 between the parties or perpetrated by either party against either party's child, including but not limited to, and they state various factors. Now, this domestic violence statute, they used to say, well, it has to be some physical threat of physical violence. Now there's emotional harm, where the person shows that they're in some fear of something happening. So you need to research that closely. And many people don't realize if there's a finding of domestic violence, usually on very brief information, a temporary restraining order, a domestic violence restraining order is issued, and then you have a hearing on the permanent to see if it should be continually extended. Many people don't realize that at the final hearing on the divorce, the domestic violence finding will come up and must be mentioned to the court. And there's various factors pertaining to the domestic violence finding that you can read. The immediate and specific tax consequences to each party. Now, I have a case where a person had 5 exemptions because there were 5 children, and the client negotiated with the other side to give up 2 of the child exemptions and keep 3, and wanted to file single. Well, that will make a big difference in terms of the tax consequences to each party. K, the balancing of hardships to each party. And L, the goal that the supported party shall be self-supporting within a reasonable time. So many times they'll make spousal support for 4 years to give the wife time or the husband time to be self-supporting. So you need to calculate that in, and in your trial, be looking for that time period. M is a criminal conviction of an abusive spouse shall be considered. And then item N, any other factors that the court determines are just and equitable. Equity is fairness or mercy. I had one case where the husband worked 3 jobs for their marriage to continue, and then I said, Your Honor, the marriage didn't continue, and so he only wants to work 1 job now. And the judge said, oh, I understand. I myself have been divorced 3 times. So that was kind of a fun thing on this area of equity. So that will be the end of our code section in this area. And remember, at trial, you need to go in with a copy of this code section, and at your final trial, go through each one of these elements and have your evidence as to how many debts you owe, what each asset is worth. There is an issue in terms of old furniture. And if you have your home furnished, what is that worth? Well, it's not worth what you brought it home for the first day after you got it on the showroom. Maybe it's worth $12,000. You can look at Craigslist ad or garage sales and put a value on each item. What you can do, you can enter into stipulations, and you can say to the other side, I think our family furniture is worth $12,000 at garage sale prices. Will you stipulate? Will you agree to that? And if they won't, then you're going to have to put on evidence and testify that you believe that the furniture is worth $12,000 or whatever amount you conclude. I always say there's an easy way and a hard way. The easy way is by stipulation. The hard way is where you have to go and put it in front of a judge and have your evidence. Some marriages, there's so much bitterness that they don't want to sell. They don't want to settle. They just want to hurt the other person as much as possible. I had a client call me once and say, have we done everything possible to hurt the client as much as possible? And that was his goal rather than to settle. I say, do you want the money to go to the children, or do you want it to go to the attorneys? I was on one case and we were arguing over the value of a condominium, and they argued so long that the attorneys about owned the condominium. So it's expensive to fight. They say talk is cheap unless you're talking with a lawyer. So beware, is it worth the fight? And try the easy way of stipulation before you go to trial. But if you go to trial, make sure that you've addressed in your final trial each of these items in the statute. This will be the end of recording number 3, and then we will continue talking about your closing argument after you present your case at trial.